California Civil Procedure Handbook Rules, Selected Statutes and Cases, and Comparative Analysis. Chapter 1, Introduction to California Civil Procedure. Subsection A, Sources of California Procedural Laws. 1. Written law. According to Section 1895 of the California Code of Civil Procedure, all laws in California are either written or unwritten. The written laws contained in the California Constitution and Statutes and in the United States Constitution and Statutes, CCP 1897. Unwritten law is law not promulgated and recorded, but which is nevertheless observed and administered in the courts. It has no certain repository, but is collected from the reports of the decisions of the courts and the treaties of learned men, CCP 1899. The United States Constitution and laws, although the origins of specific California procedural laws lie elsewhere, the United States Constitution is, in one sense, the ultimate source, both as a conceptual proposition and an actual check when challenged. All state procedural laws must be consistent with the requirements of the 14th Amendment. The Federal Due Process Clause provides the ultimate fairness standard by which state procedural statutes, rules, and court actions are measured. See Kolkel v. Superior Court of 1978. California state courts exercise a personal jurisdiction over a non-resident parent in child support action violated Federal Due Process Clause. Randone v. Appellate Department, 1971. Then existing California attachment statute, which authorized prejudgment attachment without notice of an opportunity for hearing, violated the Due Process Clause. The California Constitution, period. In addition to the general due process provision, which mirrors that of the United States Constitution, the California Constitution contains a number of more specific sections which help define our civil litigation process. For example, Section 16 of Article 1 provides with respect to civil jury trials, trial by jury is an inviolate right and shall be secured to all, but in a civil cause, 3/4 of the jury may render a verdict. In a civil cause, a jury may be waived by the consent of the parties expressed as prescribed by statute. The California Code of Civil Procedure, period. The California Code of Civil Procedure herein, after CCP, consisting of hundreds of statutes, is the primary source of procedural law for California state courts. This code covers such topics as such subject matter jurisdiction, statutes of limitation, joinder of parties and claims, service of process, pleadings and motions, attachment, trial and pretrial motions, extraordinary writs, appeals, judgments, and enforcement of judgments. Unlike the relatively succinct federal rules of civil procedure that apply in federal trial courts, the California Code is lengthy, comprehensive, and quite detailed. For example, Federal Rule 56 delineates the standards and procedures for summary judgment motions in less than one page, but CCP Section 437C takes 2.5 pages of similar size type. Federal Rule 30 specifies procedures for oral depositions in 2.5 pages. CCP Section 2025.010 through .620 require more than 10 pages to cover the same topic. The code approach employed by California usually means that most specific procedural questions can be answered by simply locating the relevant code sections. Other statutory codes also contain important procedural provisions, often limited to particular types of cases. See example, Government Code Section 900 and sequential procedures for presentation of claims against public entities and officials under the California Tort Claims Act. Family Code 200 through Section 291, procedures relating to dissolution of marriage and related proceedings. Civil Code Section 1780 and 1784, remedies and procedures for actions under the Consumer Legal Remedies Act. Evidence Code Section 450 through 460, Judicial Notice. Business and Professions Code Section 6146 through 6149, limitations on contingent fee agreements. California Rules of Court. Pursuant to the authority contained in the California Constitution and in various code sections, the Judicial Council of California has adopted numerous statewide rules of practice and procedure. These rules of court supplement statutory and constitutional provisions and have the force of law. The statutes of court were reorganized and renumbered effective January 1, 2007. The scope of the numerous and detailed California Rules of Court is difficult to characterize. Some rules govern procedures in the appellate courts, Rules 8.1 through 8.1125, California Rules of Court. Others fine-tune civil pretrial and trial procedures in the Superior Court, Rules 3.1 through 3.2120. Some specifically relate to family law proceedings, some to coordination of civil actions, and others to court annex arbitration and mediation. Rules 5.5 through 5.475, 3.500 through 3.550, 3.800 through 3.878. Some cover seemingly mundane topics such as the form and size requirements of papers presented for filing specified in Rules 2.100 through 2.119. Others provide essential information on important material not covered elsewhere, such as the time deadlines for filing a notice of appeal in Rules 8.104 and 8.108. The criteria for publication of appellate opinions, for example, are found in Rules 8.1100 through 8.1125 and no place else. You might think a detailed code of civil procedures plus hundreds of statewide rules of court would provide sufficient basis for regulation of civil procedure. Unfortunately, the California courts do not. Pursuant to each county, to the authority provided by CCP 575.1 and Government Code 68,070A, each county has promulgated numerous local rules applicable to civil actions in its superior courts. Typically, they govern such areas as local variation as to format and filing requirements for papers, the procedures for scheduling hearings, telephonic rulings, and special rules for specific departments. When the advent of the Trial Court Delay Reduction Act, local rules have taken on increased importance. 2. Unwritten law. Judicial decisions, period. Judicial decisions are a prevalent source of procedural law. The court not only interpret the written law, but possess the inherent power to make procedural law. See, for example, La Sala v. American Savings and Loan Association. Adopting procedures for class actions. Green v. Obolito, 1981, and it's the same. The general rule is that judicial decisions in civil actions are given retroactive effect. This means that a decision of the California Supreme Court overruling a former decision or announcing a new rule of law should normally apply to all sections that already have been filed or litigated but are not yet final. See, for example, Newman v. Emerson Radio Corp. 1989, observing that the California courts have consistently applied tort decisions retroactively even when those decisions declared new causes of action. Peterson v. Superior Court of 1982, concluding new rule announced by Supreme Court that punitive damages are recoverable from intoxicated driver who causes personal injury should be applied retroactively. That actually copies a case in another state too. So anyhow, however, the courts have recognized exceptions to the general rule when considerations of fairness and public policy precluded retrospective operation of judicial decisions. See example, Newman v. Emerson. Did I read this already? Radio Corp. Supra, collecting cases. Maradi-Shalal v. Fireman's Fund Insurance Companies, 1988, judicial reinterpretation of the statute to preclude private third-party causes of action for unfair insurer practices not given retroactive effect. Consideration of fairness and public policy required prospective application to permit those who had already embarked on litigation to receive the benefit of the court's express prior ruling on which they had relied. Publication of appellate court opinions, periods. Decisions on the merits by the California Supreme Court and Court of Appeal must be in writing with the court's reasons stated. Article 6, Section 14 of the California Constitution. All such written opinions of the Supreme Court are published in the official reports, for example, the multi-volume California Reports, Rule 8.1105A, California Rules of Court. An opinion of the Court of Appeal, however, is published in the official reports. See, for example, multi-volume California Appellate Reports only if it satisfies one of the criteria for procedures set forth in Rule 8.1105C. Example, the opinion establishes a new rule of law, addresses or creates an apparent conflict in the law, involves a legal issue of continuing public interest, invokes a previously overlooked rule of law, etc. Because these criteria discourage publication, only approximately 15% of the judicial opinions rendered in the various courts of appeal and civil appeals are published. See Judicial Council of California 2006 Court Statistics Report. Court of Appeal, Table 9 for 2004 through 2005. Partial publication is also authorized and is frequently utilized if the Court of Appeal determines that only portions of its opinion meet the standards for publication. It can order publication of only those portions. Rule 8.1110A, the unpublished parts are treated as an unpublished opinion. Rule 8.1110C. The California Supreme Court has the power to change the publication status of a Court of Appeal opinion by ordering that an opinion certified for publication is not to be published, or, more rarely, that an opinion not certified for publication is to be published. Rule 8.1105D2. Also, the general rule is that an opinion of the Court of Appeal is no longer considered published if the Supreme Court grants review of the decision. Same rule. D1. Citation of unpublished opinions prohibited, period. What difference does it make whether or not an opinion is published? Question. Plenty. Generally, subject to certain limited exceptions, an unpublished opinion cannot be cited or relied on by a court or a party in any other action or proceeding. Rule 8.1115, California Rules of Court. Because an unpublished or depublished opinion cannot be cited, it has no precedential value. See Nelson v. Justice Court, 1978, Keaton v. Marin County Employees Retirement, Section 1976. Improper citation to an unpublished opinion in an appellate brief may result in the imposition of sanctions. See Alicia T. v. County of Los Angeles of 1990. Monetary sanctions imposed against appellant's counsel for repeatedly citing depublished cases. Learned treatises, period. The California courts often rely on legal treatises and secondary authorities to illuminate gray areas of the law. The most authoritative treatise by far is the 10-volume California. Sorry, I think I stopped recording during learned treatise. We're talking about how Witkins has one of the most popular legal treatises on the California civil procedure. And the Rudder Group, updated annually. Secondary authorities such as learned treatises are not themselves law and do not have binding force of statutes, court laws, or judicial precedents. Nevertheless, they can be quite persuasive. For example, when construing unclear procedural statutes, the California courts frequently rely on legislative histories contained in the Judicial Council, California Law Revision Commission official comments, or legislative committee reports to ascertain legislative intent. See Bonanno v. Central Contra Costa Transit Authority of 2003. Official comments are persuasive, albeit not conclusive evidence of legislative intent. Now, in case my recording cut off, when I said something really important, monetary sanctions can be imposed against appellant's counsel for citing unpublished and depublished cases. That is something that the California Rules of Court set forth in Rule 8.1115. Alright, there's no prejudicial effect from that. Subpart B, California Judicial System. The following profile of the California Judicial System is reproduced in part from California Judicial Branch and California Courts, with additions and modifications taken in 2006 Court Statistics Report, statewide caseload trends 1995 through 1986 through 2004 through 2005, published by the Judicial Council of California. California Judicial Branch, the California court system, the largest in the nation with more than 2,000 judicial officers, 19,000 court employees, and nearly 9 million cases, serves over 34 million people. The state constitution vests the judicial power of California in the Supreme Court, Courts of Appeal, and Superior Courts. The Constitution also provides for the formation and functions of the Judicial Council, the policy-making body for the state courts and other agencies. And then there's the California Supreme Court section, Courts of Appeals, Superior Courts, before we conclude this chapter 1, and then the court system agencies. So just some more background. The Supreme Court of California is the state's highest court. Its decisions are binding on all other California courts. The court conducts regular sessions in San Francisco, Los Angeles, and Sacramento. It may also hold special sessions elsewhere. Membership, 1 Chief Justice, and 6 Associate Justices are appointed by the governor and confirmed by the Commission on Judicial Appointments. The appointments are confirmed by the public at the next general election. Justices also come before voters at the end of their 12-year terms. Jurisdiction. The Supreme Court has original jurisdiction in proceedings for extraordinary relief in the nature of mandamus, certiorari, and prohibition. The court also has original jurisdiction in habeas corpus proceedings, according to the California Constitution, Article 6, Section 10. The state constitution gives the Supreme Court the authority to review decisions of the state courts of appeal, California Constitution, Article 6, Section 12. This reviewing power enables the Supreme Court to decide important legal questions and to maintain uniformity in the law. The court selects specific issues for review, or it may decide all the issues in the case. California Constitution, Article 6, Section 12. The Constitution also directs the High Court to review all cases in which a judgment of death has been pronounced by the trial court. California Constitution, Article 6, Section 11. Under state law, these cases are automatically appealed directly from the trial court to the Supreme Court. Penal Code Section 1239B. Business transacted, period. Total filings, and then we're just talking about, 89,000 cases are going through the court system. I don't feel like reading all of the details, because I already have. And it just is from top to bottom. The Supreme Court ordered 16 Court of Appeal opinions depublished in 2004 to 2005, so it's kind of old information too. The lowest number of depublished opinions in over 20 years. The Supreme Court continued to meet its commitment to issue decisions within 90 days of oral argument or submission of the last brief. Petitions for review, period. The total number of petitions for review of the Court of Appeal decisions increased from about 5,000 in 2003 to 2004 to 5,400 the next year. Petitions, okay, up and down, it swings. And criminal is higher, a little bit of a higher percentile. Supreme Court granted 101 petitions for review. That's 65 civil, 36 criminal. And grants for all. 3 reasons. What reasons? Petitions pending an expected decision in the lead case. Petitions granted and immediately transferred back to the Court of Appeal for further proceedings. This doesn't even make sense. Okay, so the Court of Appeal is the next section. Established by a constitutional amendment in 1904, the Courts of Appeal are California's immediate courts of review. California has 6 appellate districts, each with at least 1 division. The 6 appellate districts are composed of 19 divisions and 105 justices. The 6 appellate districts are district headquarters are 1st District, San Francisco, 2nd District, Los Angeles, 3rd District, Sacramento, 4th District, Division 1, San Diego, 5th District, Fresno, and 6th District, San Jose. The legislature has constitutional authority to create new Court of Appeal districts and divisions. According to the California Constitution, Article 6, Section 3, membership. Each district or division, in the case of the 2nd and 4th districts, has a presiding justice and 2 or more associate justices. Appellate justices are appointed by the governor and confirmed by the Commission on Judicial Appointments. The same rules that govern the selection of Supreme Court justices apply those serving on the Courts of Appeal. Jurisdiction, period. Courts of Appeal have appellate jurisdiction when superior courts have original jurisdiction, and in certain other cases prescribed by statute, like the Supreme Court, they have original jurisdiction in habeas corpus, mandamus, certiorari, and prohibition proceedings. Going back to Section 10 of the Constitution in Article 6, over 21,000 appeals and original proceedings were filed in the Courts of Appeal during 2004 through 5 fiscal year. Opinions certified by publication. Cases are decided by 3-judge panels. Decisions of the panels, known as opinions, are published in the California Appellate Reports, and those opinions meet certain criteria for publication. In general, the opinion is published if it establishes a new rule of law, involves a legal issue of continuing public interest, criticizes existing law, or makes a significant contribution to legal literature. This comes from Section 14 of the California Constitution, Article 6, and Rules of Court, Rule number 8.1105. And during 2004 to 2005, 8% of Court of Appeal opinions were certified as meeting the criteria for publication. The highest publication rate, 16%, was for original proceedings, then civil appeals, 15%, criminal appeals, 5%, and juvenile appeals, 3%. Business transacted period. I'm kind of skipping this section, but you get an idea, 21,000 annually. Total filings of original proceedings rose to 8,600 cases, with civil being 2,500, criminal being 5,339. Total dispositions decreased slightly from the previous year to 24,000 in 2004 to 5, following slow but steady growth in dispositions during the 1990s. Written opinions decreased slightly to 10,900 cases, a total of 3,400 in civil in 2004 to 2005. Trial court affirmative rate. Among cases disposed by written opinion, there was little change from the previous year in the proportions of cases affirmed, reversed, and dismissed. As in previous fiscal years, almost 2/3 of civil appeals decided by opinion were affirmed in full during 2004 to 2005, and another 11% were affirmed with modifications, for a total affirmance rate of 77%. During 2004 to 5, the Court of Appeal affirmed the trial courts in 93% of defendants' criminal appeals. Case processing time. Statewide, half of the civil appeals disposed of by opinion in 2004 to 2005 took more than 433 days from notice to appeal to decision. The outlook was somewhat better for criminal appeals, for which the statewide median time for filing a notice of appeal to decision was 391 days. In both civil and criminal appeals, studies indicate that most case delay is beyond an appellate court's control. For example, appellate courts typically must wait a significant amount of time for the trial court record to be completed. The period from the filing of the record to the filing of the appellant's and respondent's brief constitutes another large block of time. After the record and briefs are filed, most courts of appeal decide cases quite promptly. Statewide, the median time for completion of briefing to opinion was 122 days in civil cases, 103 in criminal. Superior Courts, membership and qualifications period. Superior Courts have 1,498 authorized judges and 419 commissioners and referees. The California legislature determines the number of judges in each court. Superior Court judges serve 6-year terms and are elected by county voters on a nonpartisan ballot at a general election. Vacancies are filled through appointment by the governor. Jurisdiction period. Superior Courts now have trial jurisdiction over all criminal cases, including felonies, misdemeanors, and traffic matters. They also have jurisdiction over all civil cases, including family law, probate, juvenile, and general civil matters. Appeals in limited cases where $25,000 or less is at issue, and misdemeanors are heard by the appellate division of the Superior Court. When a small claim case is appealed, the Superior Court judge decides the case. Business transaction period. Superior Court filings fell slightly from 8.9 million in 2003 to 2004 to 8.9 million. I'm not giving all the hundreds and thousands. In 2004 to 2005, there were 7.5 million dispositions in 04 to 05, which was up slightly from 7.3 years prior. Civil case filings declined slightly from 1.4 million in 2003 to 2004 to 1.4 million in 2004 to 2005. Personal injury, property damages, and wrongful death filings decreased from 58,000 in 2003 to 2004 to 50,000 in 2004 to 2005. Domestic related filings, which is marital and family law petitions, also decreased slightly from 477,000 to 473,000 in 03 to 04 through 04 to 05. Civil complaint filings equaled 1.4 million during 2004 to 2005. Of these, only 167,000 were unlimited civil cases, 477,000 were limited civil cases, and 155,000 were family law marital cases, and 255,000 small claims court cases. Civil dispositions totaled 1.2 million, almost 1.3, including 149,000 unlimited civil cases. Only 1,534 unlimited civil cases were decided by jury trials, or 2.5%. 79.4% of all civil cases were disposed of before trial during 2004 to 2005, including 5.7% for delay in prosecution. Appeals filed with the Appellate Division of the Superior Court in limited civil cases totaled 4,639 in 2004 to 2005. Dispositions totaled 4,281 during that same period. Case processing time. Civil case processing time remained essentially the same as the previous year. 2004 to 2005, 64% of all unlimited civil cases were disposed of within 12 months, 84% within 18 months, and 92% within 24 months. Likewise, 83% of limited civil cases were disposed of within 12 months, 91 in 18, 94% in 24 months. Criminal case processing time did not change significantly, with 91% of all felonies being disposed of in less than 12 months. Now, the last section in Chapter 1 is called Court System Agencies. The Constitution also provides for agencies concerned with judicial administration, Judicial Council, Commission on Judicial Appointments, Commission on Judicial Performance, and Habeas Corpus Resource Center. The Judicial Council, period. The Judicial Council is the governing body of the California courts. The California Constitution directs the Judicial Council to provide policy guidelines to the courts, make recommendations annually to the governor and legislature, and adopt and revise California rules of court in the areas of court administration, practice, and procedure. The council performs its constitutional and other functions with the support of its staff agency, the Administrative Office of the Courts, chaired by the Chief Justice and Council. The council has 27 members, who include 14 judges appointed by the Chief Justice, 4 attorney members appointed by the State Bar Board of Governors, 1 member for each house of the legislature, and 6 advisory members, including representatives of the California Judges Association and Court Executive Administrators. The council performs most of its work through internal committees and advisory committees and task forces. The way I see it is, why are there even any attorneys at all? 4. Anyway, that concludes chapter